I'm Diane Drain, Arizona bankruptcy and foreclosure attorney and also a law professor. I want to talk about divorce and bankruptcy. It's really kind of complicated. People call all the time and say, I'm married, but I'm getting divorced. I need to file bankruptcy. When do I file bankruptcy? To steal from a friend of mine, Gary Stickle, it depends. So it's kind of like drawing a decision tree to figure out who's doing what. Now, I'll tell you the easiest answer to that question. If spouses are still married, they've just filed for, say, a separation, and both recognize that they can't afford to pay their bills. Certainly now that they're going to be living separate, they're going to have the overhead of two separate households, and now they can't afford their bills. Then the smartest thing they could do is to file a joint bankruptcy. It's cheaper to file jointly. Now, they don't have to file joint. They could individually file bankruptcies. And depending on the circumstances, that might be best for them. So anyway, the first step is just getting rid of all the debts that they can get rid of in bankruptcy, and doing it either together or at the same time. That's step one. Step two, one individual does not want to file. The other individual does. Divorce is is out there, and maybe a petition has been served. At that particular point, you can file. You don't have to file with your yet-to-be ex-spouse. But here's the deal. Any debts you brought into the marriage and any debts either of you had while you were married, with a couple exceptions, have to be listed in the bankruptcy. Okay? Arizona is a community property state. What that means is that while you're sitting there and your spouse is driving around buying stuff, incurring new debt, you're on the hook for the debt even though you don't even know about it. So that's a community property. There's a couple of exceptions to that. That's real estate, corporate guarantees, or sureties. But for the most part, we're talking about credit cards, medical bills, those type of things. So just understand that if you're in a situation where you're going to be divorced and you want to file bankruptcy, talk to an attorney who is very experienced in the blending of those two different areas of law and determine what the timing would be in filing for a bankruptcy. Lastly, if there's already a divorce in place and an individual is looking to file bankruptcy, there's a couple of warnings. If part of the divorce decree said that the individual who's filing bankruptcy has a legal obligation to pay certain debts, then even though they file their bankruptcy and get rid of their obligation to pay that debt, like say the American Express bill, that doesn't mean that their ex-spouse can't take them back into divorce court and basically redo part of the divorce decree, saying that now they're responsible for the American Express bill, and therefore the person who filed bankruptcy has to pay them that extra money. So you've got to be aware of that. The last note that I want to make is property settlement. The bankruptcy code is a little bit strange here. Now, property settlement is not alimony. It's not child support. It's basically assets that were to be distributed perhaps over time. In Chapter 7, the obligation to pay that property settlement or perform as pursuant to the property settlement does not go away. It still survives, just like child support and alimony survive. But in a Chapter 13, you can actually get rid of the property settlement. Not the child support or alimony, but the property settlement. So sometimes people file Chapter 13s for the sole purpose of dealing with that property settlement. I hope this was helpful. Again, I really, really recommend you get competent counsel to help guide you through as you make your decision in what to do. Thank you.